Without objection, the chair is authorized to declare a recess of the subcommittee at any time. The subcommittee is meeting today to hear testimony on examining systemic government overreach at CEQ. I ask unanimous consent that all members testifying today will be allowed to sit with the subcommittee, give their testimony, and participate in the hearing from the dais. First, the gentleman from Oregon, Mr. Bentz, the gentleman from Louisiana, Mr. Graves, the gentleman here at the dais already from California, Mr. Huffman, and the gentleman from Idaho, Mr. Fulcher, the gentlewoman from Washington, Ms. McMorris Rogers, and the gentleman from Washington, Mr. Newhouse. Without objection, so ordered. Under Committee Rule 4F, any oral opening statements at the hearings are limited to the chairman and the ranking minority member. I therefore ask unanimous consent that all other members' opening statements be part of their hearing record if they are submitted in accordance with Committee Rule 3.0. Without objection, so ordered. I'm now going to recognize myself for my opening statement. Thank you, Chairman Westerman, for joining us today. And thank you also to Ranking Member Stansberry for her leadership on the subcommittee. And thank you all of the witnesses for attending today. Sadly, CEQ Chair Brenda Mallory refused to join us here today, and she refused to provide the opportunity for someone on her staff to testify on her behalf, which quite honestly could have been a great opportunity. In the words of Supreme Court Justice Louis D. Brandeis, sunlight is said to be the best of disinfectants. But as we have seen from the Biden administration time and time again, they would prefer to operate in darkness, insisting that Congress and the American people take their word for it. President Biden has repeatedly insisted that his actions and the actions of his family are above reproach. Yet, over the last several years, and largely thanks to the work of congressional Republicans, we now know nothing can be further from the truth. Nonetheless, the personal arrogance and lack of accountability from President Biden has infected his entire administration. CEQ was once a small office charged with ensuring compliance for the limited number of agency actions that triggered the National Environmental Protection Act of 1969, or NEPA. CEQ has a targeted role with a budget to match. Today, President Biden has transformed CEQ's role from overseeing NEPA's compliance to an agency with both a bloated budget and role in government policymaking. It is an entity charged with implementing his radical ego agenda, remaking federal agencies as vehicles of social change, and leading the war on domestic energy production. As you will hear from some of our witnesses today, CEQ's role in implementing executive orders and rulemaking vastly exceeds its statutory role and prescribed authority. Examples of this include: 1, refusing to implementing bipartisan NEPA reforms from the Fiscal Responsibility Act on a timely basis. 2, improperly and arguably illegally imposing greenhouse gas reduction requirements that deter investment in American energy independence. 3, egregious favoritism towards radical ego activists pushing to breach the lower Snake River dams. And 4, selecting an internal organization funded by one of the largest left-leaning dark money groups as a sole arbiter of emission reduction mandates for the federal contractors. On what now has become a routine matter, CEQ is ignoring the will of Congress, whether it be refusing to provide a witness for a hearing or to provide timely answers to routine congressional inquiries. No other federal agency has allowed this lack of accountability, and this behavior is unacceptable. It is Congress's responsibility to assess whether federal agencies and departments are operating in effective, efficient, and economical manners, and to gather information that may inform legislation. Instead, before he was president, Democrat Woodrow Wilson emphasized that Congress's oversight and informing function should be preferred even to the lawmaking function. Woodrow Wilson also added that unless Congress conducts oversight, the country must remain in embarrassing, crippling ignorance of the very affairs which it is the most important it should understand and direct. Time and time again, it appears that CEQ hopes that the public remains in crippling ignorance of its work. Well, I have news for Chair Mallory and President Biden: not on my watch. We will continue to hold CEQ accountable, and we will continue to seek answers on the very questions CEQ refuses to answer. We will also ultimately use every tool at our disposal to obtain the information we need from CEQ, including on rulemaking, on NEPA reforms, on CEQ's relationships with radical eco-activist organizations, and on CEQ's potential abuse of federal solicitation process to curry favor with dark money groups supporting Democrats. Despite the best efforts from Chair Mallory and President Biden, CEQ will not escape the watchful eye of Congress's oversight. Thank you to all of you. I look forward to the hearing. I now recognize the Ranking Member Stansberry for her opening statement.
Good morning, and I want to just start by welcoming all of our witnesses who are here to testify today, and thank you to our chair and to all of our colleagues who are here today. It's interesting to always have these debates and to discuss differing views of the world and how we see what is happening in the world, and I think today really paints a stark picture in the differences in how we view what is occurring on our planet and in our country right now. In the 1970s, in the late 1960s and 70s, as they dawned, our country had come to understand some of the damage that it had inflicted upon itself. The Cuyahoga River was on fire. Iconic rivers across the West were being dammed and causing catastrophic results for communities that had relied on them since time immemorial. Tribal lands were being physically damaged. Mines and other projects were being permitted in proximity to vulnerable communities. And our food, water, and air, which we thought, of course, would always be there to sustain us, were in jeopardy. And because of this, our nation came together and in 1969 passed one of the most fundamental bedrock environmental laws. The National Environmental Policy Act was passed and signed into law by Republican President Nixon on January 1st, 1970, and it was dubbed the Magna Carta of environmental laws as a direct response to the environmental crises of the 1960s and 70s that was occurring. Now, indeed, our planet, our country, our communities is facing another crisis as we sit here today and stands at another global precipice. Last summer was the warmest summer in recorded history. We are seeing tropical storms and hurricanes stronger than ever, with flooding that is occurring all across the planet, including in Libya, where over 5,000 people were killed this last week and another 10,000 are missing. We're seeing wildfires that are the worst wildfires ever in the history of our planet that can be seen from space. And we are seeing some of the biggest impacts of drought that we've ever seen, including in my home state of New Mexico, where our river, the Rio Grande, ran dry again this past week. These are exactly the kinds of crises that Republicans and Democrats had in mind when they came together and passed NEPA on a bipartisan basis, because they understood that if we did not empower our communities and stop the damage that we're doing to our environment, that we could cause catastrophic impacts for our communities. And that is the purpose for why we passed NEPA. But yet, here we are once again in this committee holding another oversight hearing on the implementation of this critical bedrock legislation at a time that our country is standing at a precipice. And I'll remind folks that this is the third hearing that we've had on this specific topic. But it's important to note that the President, Democrats last Congress, rose to the occasion. We are working every single day to try to address this crisis. Last year, we passed the largest and most significant legislation ever in the history of the planet to address climate change with the passage of the Inflation Reduction Act. Across the country, the president, his cabinet, and Democrats are rolling out projects, including in my home state in New Mexico, where we just started and dug ground and cut ribbon on 3 new projects, including one of the largest wind turbine factories in the United States, the first solar manufacturer to repatriate to the United States since the passage of the Inflation Reduction Act, and we cut ribbon on the largest wind project in North America in the Western Hemisphere just 2 weeks ago. We are at the forefront of the clean energy revolution and understand that if we do not take urgent action now, it will have catastrophic and irrevocable impacts for our communities. And that is also why the chair of CEQ is not here today, because she is out on the ground doing the work to ensure that we prevent a catastrophic crisis for our planet and our communities. And that is the work that we have been tasked with as this body, as representatives of our communities, and as people who serve this great nation. So I look forward to the discussion today. It's an important discussion. It's a discussion about the role of government in serving our communities in times of crisis, helping our communities get through what is possibly one of the most difficult chapters in American history, and addressing the many faceted environmental crises that we're facing right now in this country and on this planet. Thank you, and I yield back.
Thank you, Ranking Member Stansberry. I now recognize the Chairman of the full Committee of Natural Resources, Mr. Bruce Rusterman, for his statement.
Thank you, Chairman Gosar and Ranking Member Stansberry, for holding this important hearing today, and thank you to the witnesses for being here. I do want to point out we have an empty seat in front of us again. The Council on Environmental Quality is not exempt, regardless of what they may think, from congressional oversight. I want to make the record clear that we not only invited Chair Mallory with plenty of notice, but also allowed her to provide a designee for this hearing. And in response, her staff stated that, and I quote, "We do not have a designee for Chair Mallory that will be available to testify on September 14th. So not only did she not show up, she couldn't find anybody in the office over there to come by and visit with the committee that has jurisdiction over her agency's existence. And to me, that's just quite simply unacceptable. Moreover, in email exchanges with my staff, CEQ staff questioned the precedent of congressional oversight. The Supreme Court has, on multiple occasions, clarified the power of Congress to conduct oversight and investigations. Apparently, the chair thinks this doesn't apply to her tenure at CEQ. And since her time as chair of CEQ, Chair Mallory has now twice refused to testify in our committee, willfully ignored questions from members of Congress during the hearing. She avoided the questions during the one hearing that she did show up to, and missed deadlines for regular congressional inquiries and questions for the record. And my staff informed me that late last night, they got a data dump of questions that were answered from our last congressional hearing that had gone unanswered up until this point. So while ignoring routine oversight, the chair and her employees at CEQ are continuing to do I don't know what, because the purpose of oversight is to find out what they're doing, why they're doing it, and how they're being stewards of the taxpayer dollars, and are they following the laws that Congress passed. And again, I'm not sure what they're doing with their time and their massive overinflated budget that is nearly 70 times their authorized amount, but it doesn't appear to be in enforcing a bipartisan law that their boss, President Biden, signed into law. And we're 100 days past the implementation of the Fiscal Responsibility Act that passed with a majority of votes in both the House and the Senate on a bipartisan measure, and was signed into law by President Biden. And the feedback I'm getting from the outside world is that not one bit of that policy is being implemented. So I think that's a reasonable request to have the chair of CEQ to come to this committee and answer questions on how they're implementing the law that, again, was a bipartisan law. And from 2019 to 2023, CEQ's baseline budget more than doubled, and they received an additional $62.5 million from the Inflation Reduction Act to support environmental and climate data collection. In short, the administration is funneling millions of taxpayer dollars to an agency whose, at best I can tell, primary goal is, quote, environmental justice above all, while that agency refuses to answer questions from the representatives of the American public. Well, I can tell you that actions have consequences, and those who don't show up to work generally don't get paid. And to quote a president from long ago, from the other side of the aisle, the buck will stop here. It stops in Congress. We're the ones that send the money to the administration. And I will be working with my counterparts in the Appropriations Committee to ensure that we put a stop to egregious behavior and look to fund CEQ at a level that is commensurate with its accountability and the American its accountability to the American people and its congressionally authorized levels. And something that's still true today according to our Constitution is that Congress makes law and the administration enforces the law. And we may have a lot of great policy ideas, we may have philosophies on society, there may be outside activist groups who think the world should operate this way or it should operate that way. But at the end of the day, according to our Constitution, the law rules, and it's the law that Congress passes and that the administration signs. And when we have an agency that deviates from that, it's Congress's responsibility, it's our duty as representatives of the people to hold the administration accountable. And that's the purpose of this hearing today. I do want to again thank the witnesses that are here. I think you can provide important information about the real-world impacts of the actions of CEQ, and I look forward to hearing the testimony. Again, Chairman, thank you, and I yield back.
Thank you, Chairman Westerman. Now I will introduce our witnesses. As we have stated before, we invited Chair Mallory from the White House's Council on Environmental Quality. While she refused our invitation and she declined to send a designee, we still did reserve her a chair in case she changes her mind. We now have Mr. Mario Loyola, Director of the Environmental Finance and Risk Management Program and Research Assistant Professor at Florida International University Institute of Environment. There's a mouthful. Ms. Jill Heaps, Senior Attorney at Earth Justice. Mr. Scott Sims, CEO and Executive Director, Public Power Council. And Mr. Marlo Lewis, Senior Fellow at the Competitive Enterprise Institute. Let me remind the witnesses that under committee rules, they must limit their oral statements to 5 minutes, but their entire statement will appear into the hearing record. To begin your testimony, just press the on button on the microphone. We use timing lights here, so when you begin, the light will turn green, and at the end of those 5 minutes, it will turn red. I ask you to kind of please summarize and complete your statement if you start seeing the yellow. I will also allow all witnesses to testify before having members asking their question. I now recognize Mr. Loyola for his first 5 minutes.
Chairman Gosar, Ranking Member Stanberry, members of the committee, thank you for the honor of appearing before you today. My name is Mario Loyola. I teach environmental law at Florida International University, and I'm also a fellow at the Heritage Foundation. Under President Donald Trump, I served as Associate Director for Regulatory Reform at CEQ, where I was intimately involved in developing the One Federal Decision policy and the 2020 rule revision. I'm appearing before you today in my individual capacity and not as a representative of FIU or the Heritage Foundation. I have submitted more detailed comments for the record and will just make a few points now. The delays and uncertainties of the federal permitting and environmental review process are an enormous burden for American society and a very dangerous competitive disadvantage compared with countries like China. Not only does it deprive Americans of the modern infrastructure that they need and deserve, but even the scale of the renewable energy deployment that would be required for the clean energy revolution that Ranking Member Stanberry mentioned is completely impossible under current law because of the limits to the amount and the speed at which renewable energy capacity can be permitted. Within the executive branch, Presidents Bush, Obama, and Trump all tried to tackle this problem of inefficient permitting. But President Biden, unfortunately, appears to have thrown in the towel on permitting reform. One fact that's incredible to me really bears this out. During the Trump administration, the rate at which renewable energy capacity was permitted actually doubled from 2017 to 2020. Under the Biden administration, it has actually gone down. And the amount of renewable energy capacity that was permitted last year was lower than in 2020. The Fiscal Responsibility Act's historic amendments to NEPA were a huge step forward for permitting reform. But some of the most important provisions are not self-executing and require active implementation by CEQ. Unfortunately, CEQ appears to have gone in the opposite direction. Perhaps to placate the radical left or for whatever reason, CEQ has sought to undo the Trump-era reforms, of which, ironically enough, the renewable energy sector was arguably the primary beneficiary. I'll name a few examples. Where the Fiscal Responsibility Act tries to clarify that only a limited set of reasonable alternatives to the agency action need to be studied in detail, CEQ has reintroduced the concept of studying alternatives outside the agency's jurisdiction. Even worse, it has created a new requirement that the agency identify and study in detail the environmentally preferable alternatives, which is not a statutory requirement in NEPA, for significance determinations. CEQ has again gone back to the 1978 regulation and revived the context and intensity factors, thereby expanding what should be a single factor inquiry for the agencies into a dozen or more factors that they have to consider. Likewise, CEQ has reintroduced the concept of cumulative impacts into the definition of effects that must be studied. And here, I'll just stop and make a point that it's very important for the committee to be clear about and for the committee to make clear for the American people, which is that these added procedural burdens that CEQ has reintroduced into the NEPA process are not judicially enforceable against federal agencies. CEQ has no rulemaking authority. The CEQ regulation is really just an executive order, like Executive Order 12866. And no matter what level of deference courts give CEQ, whether it's substantial deference as the Supreme Court has indicated, or more controlling deference as lower federal courts have mistakenly done, it simply cannot be the case that the statutory term effects of the agency action can include the effects of other actions that are not related to the agency actions, which is, of course, the concept of cumulative impacts. Likewise, the time limits and page limits in the Fiscal Responsibility Act are not self-executing and require CEQ guidance. Here, it's very important that agencies not be allowed unfettered discretion to start the clock ticking whenever they want. Finally, the definition of major federal action, CEQ must make clear that it is the action and its impacts that must be within the agency's control for NEPA to be triggered. There is more than enough capital in the private economy to build all the infrastructure that America needs if government would just make the process more predictable. Congress wouldn't have to be borrowing trillions of dollars from our children and grandchildren to subsidize infrastructure if we could just remove the uncertainties that the process contains today. I've made several recommendations to that effect in my submitted testimony, and I look forward to answering your questions. Thank you very much.
Thank you, Mr. Loyola. I now recognize Ms. Heaps for her 5 minutes.
Good morning, Chair Gosar, Ranking Member Stansberry, and members of the subcommittee. My name is Jill Witkowski-Heaps. I'm a public interest attorney at Earth Justice and an expert on NEPA. I've been helping communities navigate NEPA issues for almost 2 decades. I've also been briefed by my Earth Justice colleagues in order to provide testimony today on the Lower Snake River restoration. I'd like to start today with a story of how NEPA saved the Lower Ninth Ward in New Orleans. Pam DeShiel and her neighbors in the Holy Cross neighborhood were concerned when they learned that the Army Corps of Engineers had to plan to dredge toxic muck from the bottom of the Industrial Canal and pile it up in the marsh next to the Lower Ninth Ward. The Corps approved the dredging plan without figuring out exactly what pollutants were at the bottom of the canal, how deep they were, how toxic they were, and even if it was safe to put that pollution in the marsh. Pam and her neighbors from the Holy Cross Neighborhood Association sued the Corps for failing to comply with NEPA. While the suit was pending, on August 29th, 2005, Hurricane Katrina slammed into New Orleans. The area where the Corps planned to put the toxic muck was inundated with 19 feet of high-velocity erosional water. Had the toxic material been stockpiled in the marsh when Katrina hit, that toxic material would have spread all over the Ninth Ward and likely other parts of New Orleans, potentially rendering them unsalvageable after the storm. The court agreed that the Corps failed to take a hard look at the environmental consequences of its action. And this is how NEPA and a community's ability to hold agencies to comply with its mandates saved the Lower Ninth Ward so Holy Cross neighborhood could rebuild after the storm. Many of the communities and environmental justice leaders I've worked with over the course of my career recognize NEPA's unfulfilled promise. NEPA's primary purpose is for agencies to take a hard look at the effects of a project, but in practice, agencies treat the affected community as an afterthought, a box to check. If no one bothers to sit down and have a conversation with the community until the project is a done deal, then the NEPA document is a paperwork exercise. Many communities suffer because they are literal and figurative dumping grounds so the rest of us can live in neighborhoods free from air and water pollution, noise, and traffic that they are saddled with. These communities are dying a death by 1,000 cuts. And here's where NEPA, a law where the federal agencies are supposed to be looking at cumulative impacts of a project, a law that could alleviate more harm to already overburdened communities. But in practice, agencies sometimes overlook, ignore, and downplay the cumulative environmental impacts to the community. Or if they do look at the impacts, the agency may claim the impacts are not disproportionate, as if the communities had the exact amount of pollution that they deserved. The Phase 2 regulations are a step in the right direction to fulfilling NEPA's promise of better federal decisions that involve the public in decision-making process. The regulations codify what many courts have already told us. Environmental justice and climate change analysis are key elements of NEPA reviews. If an agency relies on mitigation measures to determine the impacts are not significant, provide certainty that that mitigation will occur. Use plain language in the documents. Involve affected communities early in the process. All of these things will lead to more clarity in the rules, early and more meaningful community participation, and ultimately quicker and better decisions. As for the issues with the Lower Snake River, the 4 federally owned and operated dams on the Lower Snake River have decimated salmon populations. This has had enormous impacts on the 4 Columbia River Basin Treaty tribes who reserved their right to fish in treaties with the United States government in exchange for 13.2 million acres of land. It's time for a comprehensive basin-wide solution that restores the Lower Snake River, honors the treaties, and makes stakeholders whole. Thank you for the opportunity to speak with you today, and I welcome your questions.
I thank the gentlewoman. I now recognize Mr. Sims for his 5 minutes.
Good morning, Chairman Gosar, Ranking Member Stansberry, and members of the subcommittee. My name is Scott Sims, and I serve as the CEO and Executive Director of the Public Power Council, or PPC. PPC represents a majority of nonprofit consumer-owned electric utilities operating in rural and urban areas of the Great Pacific Northwest that purchase electricity and transmission services from the Bonneville Power Administration, or BPA, and they collectively pay 70% of BPA's $3.9 billion annual revenue requirement. Our utilities fund the nation's largest ESA effort. We have a keen interest in ensuring that fish mitigation measures are science-based, cost-effective, and have a clear nexus with the operations of the Federal Columbia River Power System, or FCRPS. We are fully committed to paying our share of mitigation responsibilities, but no more and no less. This balance is what enables PPC members to offer affordable, reliable, clean, and environmentally responsible power to the communities they serve. Unfortunately, the FCRPS operations have been mired by long-running litigation. Roughly 13 months ago, the federal district court judge overseeing litigation in the Columbia Basin operations approved a stay, while the CEQ engaged the Federal Mediation and Conciliation Service, FMCS, to resolve the issues being litigated. While the stay was set to expire on August 31, 2023, the U.S. government and the plaintiffs requested, and the court subsequently granted, a 60-day extension of the stay until October 31 of 2023. So PPC entered these CEQ-led negotiations with guarded optimism that the mediation process would be finally pursued in a fair, confidential, and collaborative manner led by skilled third-party mediators. Regretfully, our experience has been to the contrary. It has been a frustrating, bureaucratic process with little discussion of new ideas and much less progress toward regional compromise. Labeling any of this as mediation was a sham from the beginning, and it's quite an abuse of the very word. What CEQ has done is put a thumb squarely on the scale for certain parties. That was evidenced by the sideboards set for the stay in litigation and subsequent mediation. PPC has repeatedly raised new ideas and proposed tangible solutions, yet no substantive action has come of these efforts because CEQ refused all offers. At most, we have basically received a pat on the head. We have serious concerns that many of the topics being discussed are likely outside the plaintiff's areas of expertise, or at a minimum, are topics where we have immense expertise that we could share. In any event, we should be in these discussions early, not as a last step to sign on. We are dismayed at what was sold to us as a solutions-based mediation process. So this is detailed and more explicitly in my submitted report, but let me just share here that we at PPC recruited credible third-party biologists to point out the serious flaws in a report CEQ conveniently floated as NOAA's so-called latest science, for which CEQ uses as a basis to push a specific agenda. This new NOAA report, Rebuilding Interior Columbia Basin Salmon and Steelhead, has apparently paved over NOAA's prior decades of established scientific evidence and record. CEQ probably didn't like us raising the issue of a sudden 180-degree shift at NOAA, so we were just ignored when we first raised the issue and continue to be ignored to this day. Let me be clear for everyone as a witness here today at this hearing. This so-called new NOAA report is the flimsy house of cards CEQ built and is trying to keep upright in order to justify its biased approach in this process. The challenges of supplying affordable, reliable electricity services, which is now widely considered a basic need for human survival, is only becoming more difficult for today's utilities. We also have a growing concern about adequately meeting the needs of vulnerable communities, which are intensifying in rural and urban areas alike. As I work toward my conclusion, let me connect some dots here. While this administration contemplates operational changes to the dams, I must emphasize that this also has a devastatingly detrimental impact on system reliability. Ironically, it would also have a huge negative impact on meeting the administration's climate goals by reducing the amount of clean, renewable hydropower produced. Simply put, any operational changes this administration might suggest that would breach dams, increase spill, or draw down water would have grave implications for communities in the Northwest. A crucial component of BPA's predominant hydropower fleet is the target by in this process, and that's the lower Snake River dams. These dams are some of the biggest producers and lowest cost hydro units in BPA's federal system. They are an invaluable resource for the entire West, even beyond BPA's territory. They also help integrate wind and solar power into the grid, and importantly, come to the rescue when power crises hit the West, which is a dynamic we are seeing more and more often, certainly mentioned this morning by Ranking Member Stansbury. Despite the invaluable role played by these dams, very special interests continue to fuel a campaign to devalue and even destroy them. Thank you for your leadership in hosting this hearing today. We greatly appreciate the committee's focus on this critical set of issues and seeking transparency from CEQ for all Americans. I would gladly answer any questions.
Thank you, Mr. Sims. I now recognize Mr. Lewis for his 5 minutes.
Chairman Gosar, Ranking Member Stansbury, and honorable members of this subcommittee, thank you for the opportunity to testify on government overreach at CEQ. I am Marlo Lewis, an energy policy analyst at the nonprofit Free Market Competitive Enterprise Institute. My testimony develops 3 main points. First, CEQ's attempt to align NEPA project reviews with the administration's climate policy agenda is unlawful under the Supreme Court's Major Questions Doctrine. The proposed alignment entails a major shift in national policy, yet it lacks anything like a clear congressional authorization. The terms climate, global warming, greenhouse, or carbon occur nowhere in NEPA. CEQ's January 2023 proposed guidance on greenhouse gas emissions concedes that NEPA does not require agencies to prioritize climate change mitigation. But then, in the same breath, CEQ gives agencies their marching orders, quote, "In line with the urgency of the climate crisis, agencies should use NEPA to help inform decisions that align with climate change commitments and goals," unquote. Footnotes to this and similar passages reveals that agencies are to align NEPA proceedings with President Biden's Paris Agreement pledge to reduce U.S. emissions 50 to 52% below 2005 levels by 2030, and with the net zero 2050 target. Now, someone might say, well, that's just guidance. It's not legally binding. But executive agencies typically follow presidential orders. Thus, when finalized, the guidance will in practice bind agency actions until it is overturned in court or repealed by a future administration. Moreover, CEQ has big plans for the GHG guidance. In the Council's July 2023 proposed NEPA implementing regulations, CEQ proposes, quote, "to codify the guidance in whole or part," unquote. Thus, both effectively and formally, CEQ aims to require agencies to vet project proposals in light of the administration's aggressive GHG reduction targets. A net zero aligned permitting process would be adverse to any project anticipated to increase emissions either directly or by inducing economic growth. CEQ flouts West Virginia versus EPA, just as the EPA's Clean Power Plan attempted without clear authorization to suppress investment in GHG-emitting power plants, so CEQ's proposed guidance attempts without clear authorization to suppress investment in GHG-emitting infrastructure. No statute passed by Congress makes the President's Paris Pledge the law of the land. None authorizes agencies to use net zero as a factor in permitting decisions. My testimony's second point is that a net zero-aligned NEPA process is unlawful on statutory grounds. NEPA is concerned with agency actions, quote, significantly affecting the quality of the human environment, unquote. It is well known, and CEQ has acknowledged since 2010, that the GHG emissions of even the largest infrastructure project have no significant impact on the quality of the human environment. Finally, my testimony disputes CEQ's claim that America, quote, faces a profound climate crisis, allowing little time left to avoid a dangerous, potentially catastrophic climate trajectory, unquote. That claim conflicts with 50 years of dramatic improvements in global life expectancy, per capita income, food security, and various health-related metrics. Of particular relevance, the global annual average number of climate-related deaths per decade has declined by 96% since the 1920s. Factoring in population growth, the average person's risk of dying from extreme weather has declined by more than 99%. Similarly, global weather-related losses per exposed GDP have declined about 5-fold since the 1980s. In short, there is no bona fide emergency, such as might seem to justify the Council's overreach as, quote, a desperate measure for desperate times. Thank you very much, and I look forward to your questions.
Thank you, Mr. Lewis. I'm now going to go to the dais for their 5 minutes. I recognize the gentleman from Oregon, Mr. Bentz. For his 5 minutes.
Thank you, Mr. Chair. Mr. Sims, I held a hearing as chair of the Water Subcommittee of Natural Resources up in Richland, Washington back in June, and it became apparent that from the testimony of some of the witnesses from various government organization agencies that we weren't going to get the straight of what was really going on, and that is a blatant attempt to circumvent congressional authority to breach or remove those 4 lower Snake River dams. And by blatant attempt, I mean an attempt to use operational neutering, as I've chosen to call it, of those 4 projects, as opposed to actual breaching of the dams. That seemed to be, that was the conclusion I reached in that hearing. Can you comment?
Well, good morning, Congressman Bentz. Thank you for that opportunity to respond. The situation in the region is exactly as you described and what has been provided by testimony and others. These dams are being hobbled operationally. The folks that are pushing an agenda for their breaching or the removal are trying to make them less significant, less operationally significant than what they have done historically. And I think that has been an effort by folks to be continued on a single focused path of breaching or de-optimizing them, no matter which way they can work that. And you're right, Congress does have the authority, and I appreciate you as a member of Congress stressing that authority. It's been affirmed by both the Democrats and the Republicans that Congress is the single writing authority on those lower Snake River dams and the dams in general and their authorizations. I'll conclude by saying that there is an established record by the U.S. government, the Columbia River System Operations Environmental Impact Statement issued in September of 2020. And that was the U.S. government's view after an exhaustive multi-million-dollar effort involving stakeholders across the basin, that those dams can and should exist with some very minimal efforts and investments around them, because of course we are paying the world's largest Endangered Species Act mitigation program currently, And that was and is the government's record that stands today, despite the shenanigans from CEQ.
Right, and the shenanigans are being driven by CEQ, as you just said, as I understand it. But that was certainly not clear from my questions to, I think it was NOAA and Bureau, or CORE, I think it was CORE that was there. And there seemed to be a huge reluctance to share with the public exactly how this incredibly important decision to the Northwest was going to be made. Do I have that right, that this is being conducted in secret, this attempt to operationally destroy those 4 projects? And that we'll learn, I guess, when Judge Simon issues his order, if he does, on October 31st. And so how can one justify, if you're part of the CEQ, such an approach to such an incredibly damaging activity in the Northwest?
Sir, it's a great question. I would say I'm not standing in the shoes of CEQ, and having been witness to 25 years of federal, state, and regional process around these federal facilities and around the power system in the Pacific Northwest, it's incredibly difficult and very complex and requires the involvement of a lot of stakeholders. That's typically how we have moved policy in our region, is by transparent involvement of all sectors, making sure that folks are read in and understanding where things are headed and when they have a voice. And that has been completely the opposite, unfortunately, in the situation with CEQ. And as I outlined in my brief comments today, but also submitted comments, the NOAA report that CEQ had a hand in and has essentially put its basis upon is completely different than the decades of NOAA research and science on these issues to date. And we believe that has been the fuel, essentially, for the CEQ fire to burn down our region and effectively sidestep any kind of public process.
Right, thank you for that. And Mr. Lewis, what in your opinion is the most egregious expanse of CEQ power under the Biden administration?
What specifically is, sir?
Yeah, just give me one. Give me the one you think is the worst.
Well, I believe that having walled off...
Actually, it was actually for Mr. Lewis.
Oh, I'm sorry.
That's okay.
Pardon me, thank you.
Yeah.
I'll yield to Mr. Lewis.
Sure.
Sorry. I'm not sure I can give you an example because I'm not really following CEQ's actions with respect to particular projects or locations the way Mr. Sims is. He's really the expert here. I was looking at the abuse of power that I was looking at was the way they are trying to stretch a statute that was never intended to be a framework for climate policy into such a framework. And I mean, it's well known that NEPA does not even require agencies to elevate environmental concerns above other considerations when they deliberate on whether or not to grant a permit or approve the construction of a project. And here, what I'm finding is that CEQ wants to elevate the president's very specific climate goals and commitments, which are not commitments in law, but just of administration policy, into a make or break factor for deciding on whether projects should be allowed. I mean,
and we're going to have to stop there.
Okay.
My time has been exhausted. But
okay.
Thank you so much.
Yes, that's basically my notion of what their abuse is that I was concerned with.
Thank you. Yield back.
I think the gentleman from California, Mr. Huffman, is recognized.
Thank you, Mr. Chairman. Mr. Chairman, forgive me for being a little bit cynical about the work of this subcommittee this morning, because I just see an awful lot of gaslighting and projection and performative partisan theater, ranting about dark money environmental groups while trotting out witnesses from the darkest of dark money right-wing groups in this hearing. Give me a break. Getting us started by climbing on a high horse, thesaurus in hand, and calling the Biden administration and CEQ Chair Mallory every name in the book because she dares to undo some really wrong-headed Trump administration policies because she's trying to make sure we consider climate change and impacts to disadvantaged communities when we move forward with projects. You know, I'm old enough to remember during the 4 years of the Trump administration when we tried to do oversight, which apparently suddenly the Republican majority thinks is really important. And what we got back from the Interior Secretary when we wanted to find out if he was doing business still with his former oil and gas industry clients, because we unfortunately confirmed an Interior Secretary that was a lobbyist for the oil and gas industry. When we wanted to ask about that, we got pages and pages of fully redacted, empty calendar entries. We got nothing. But that was just fine with the Republican majority during the Trump administration, because they knew that that Secretary of Interior was doing the bidding of their puppet masters in the oil and gas industry. It's also rich to hear the chairman of the full committee wax sanctimonious about the Fiscal Responsibility Act, and apparently the CEQ chair is not being forceful enough in implementing the gimmicky NEPA reforms that were in that piece of legislation, and they were nothing more than gimmicks. While at the same time, our Republican colleagues are proceeding to tear the Fiscal Responsibility Act into tiny little pieces as they push our country to the brink of a government shutdown in violation of the agreement behind that legislation. So this is all a lot of partisan theater, and that goes for the discussion about the Lower Snake River dams as well. We know that our Republican colleagues recently said that the NIMS 2022 report was untethered from scientific standards and statutory authority. Mr. Sims added a rhetorical flourish saying that it was a house of cards, a flimsy house of cards that CEQ built. Well, you know, we've had 20 years of litigation over biological opinions on these Lower Snake River dams, and every single lawsuit has found that we're not doing enough to meet the standard of avoiding jeopardy, much less getting the salmon in the Columbia River Basin on a path toward recovery. So based on all of this science, it sure looks to me like this is more than a house of cards. It looks like seriously considering what these Lower Snake River dams are doing to salmon in the Columbia River Basin is inevitable. Certainly under the Endangered Species Act, and also if you give a damn about salmon, if you give a damn about tribes, if you give a damn about the dwindling orca populations in Puget Sound. Let me just ask Ms. Heaps, what am I missing here?
Congressman Huffman, I think you're right on the point. CEQ's undoing what happened in 2020 with the regs and taking the step forward to really implement NEPA for what we need today, to address climate change, to address environmental justice. And I'd also like to say that, voices that are missing here, where's the tribal representation? I mean, that perhaps is the most stark point that hasn't been made yet, is that we have a government obligation to the tribes, that they have treaty rights to these fish, and that is our number one thing that we have done wrong, and that should be the priority here, is centering the tribes and fixing these salmon runs so that they have their tribal treaty rights.
Thank you. The salmon in this basin are trending towards extinction, despite all the money that we've been spending on mitigation, correct?
Yes, that's true. The NESPERS actually, in fact, said extinction is imminent if we don't do something
So
now.
rather than just the usual thoughts and prayers we hear from our colleagues across the aisle, shouldn't we follow the science and do what we need to do if we care about salmon and tribes and all of the economic benefits? We heard the world would end if these dams came out, but aren't there a lot of economic considerations when it comes to salmon in the Columbia River Basin?
Yes, absolutely. And also, it would give, breaching the dams would give an opportunity to actually diversify the power system and actually increase reliability of the power system and open up additional recreational opportunities as well.
I thank the witness and yield back.
I think it's kind of rich of what we want, and to understand the Constitution is about the law. So I now recognize the chairman of the full committee, Mr. Westerman.
Thank you, Mr. Gosar, and thank you to the witnesses. And Mr. Huffman, I honestly don't know if you voted for the fiscal responsibility, but regardless, it's still the law. I know you might want to call it a gimmick, but it's a gimmick that had bipartisan support, and President Biden signed it. And the point is, it is the law. And Ms. Heaps, your testimony, I appreciate your testimony because it was passionate. It was a plea for policies, but it was a plea for policies that have never been passed into law by Congress. It would be fitting for a testimony at a hearing on legislation, but I think it's somewhat irrelevant on a hearing for oversight of an agency regarding established law. And I think this gets to the root of the problem. It illustrates where the breakdown is in the process. Ms. Heaps, a July 5th Earth Justice blog post stated, and I quote, "Radical Republicans are actively trying to weaken NEPA. They're trying to make it easier for industry to build toxic facilities in communities already overburdened by the worst impacts of climate change and pollution," end quote. Now, I want to point out that that post goes on to talk about how the NEPA Phase 2 requirements should focus on environmental justice and ensure climate change is part of the review process. This was published on July the 5th, 2023. The CEQ proposed Phase 2 NEPA regulations were published in the Federal Register on July 31st, 2023. Those regulations more closely mirrored recommendations in the Earth Justice blog post, not the reforms agreed upon in the what's been called gimmicky Bipartisan Fiscal Responsibility Act. So yes or no, Ms. Heaps, did you or a member of the Earth Justice team meet with CEQ regarding the development of the proposed Phase 2 NEPA process?
I am one employee at a very large organization that has 500 employees, and so I am not familiar with who
So
is
you
meeting
didn't-
with who.
you
I did
didn't-
not personally meet with CEQ, no. That's all I can speak to.
Did you or a member of Earth Justice participate in drafting the Phase 2 regulations?
I do not have knowledge to that. I did not.
Is there somebody at Earth Justice that would have knowledge of that?
Can you explain what you mean by
Did you meet?
writing the Phase 2 regulations? Because my understanding is this is a administrative process in which all of America actually participates in the regulation writing because there's a
But did you
draft
meet with,
regulations.
did you or an
and then it goes
employee
through
meet
notice
with
and
Earth
public-
Justice is what I'm asking? Or meet with CEQ regarding these Phase 2?
I have not met with CEQ about
Did you or a
Phase 2
staff
regs.
member of Earth Justice have access to an advanced copy of the CEQ proposed Phase 2 regulations prior to their publication in the Federal Register?
CEQ does a notice of advanced proposed rulemaking, and so all of America had an idea of what Phase 2 was going to look like.
So you had an advanced copy? That's my
I'm not
time.
sure what, no, I didn't say I had an
So,
advanced copy. I said the
Are
rulemaking
you-
procedures allow.
Are you or Earth Justice, as a nonprofit, currently a party and/or representing a party in litigation against the federal government?
We are not a party, no. We are lawyers.
Are you representing a party in litigation against the federal government?
Are we representing a party in litigation? Yes.
Do any of these lawsuits involve NEPA?
I am not, I have personally represented parties on NEPA at Earth Justice.
Is this a
I don't know what, I don't
So
have a.
Is this a potential conflict of interest for Earth Justice and/or its employees?
Absolutely not.
Okay, for the record, Ms. Heaps, I'd like to note that your disclosure for the committee states that Earth Justice is not a party to any litigation against the federal government, despite the fact that it uses this as an advertising tool in its tagline and on your website. So do you feel, again, yes or no, is falsification of information to
Will the
Congress
gentleman
acceptable?
yield, please?
No.
Gentleman's question will stand. You
Yeah,
need an answer.
I answered that question truthfully. Earth Justice is not a party to litigation, and that's what the question asked for.
The question was a party to or representing a party in litigation.
That's not what the question asked. It was a party to litigation. If you'd like a list of the litigation to which Earth Justice is currently in litigation, I'm sure we could find.
I've got a
list.
whole list of other questions. If I'm out of time, we will submit those questions. I've also got questions for the other witnesses, but I'm out of time and I yield back.
The gentleman from Montana is recognized for 5 minutes.
Thank you very much, Mr. Chair. Thank you, Ranking Member Stansberry, for holding this hearing today. President Biden's big government climate activist agenda has wholly captured the once small Council on Environmental Quality, transforming it into a compliance council to an activist organization. President Biden's CEQ is hell-bent on implementing climate and social policies that are destroying our country's energy, production, and jobs. CEQ Chair Brenda Mallory, who was too scared to face this committee today, has previously described her role as focusing on addressing the environmental justice and climate change challenges. Nowhere in CEQ's authorizing charter does it mention environmental justice, nor did Congress grant CEQ the power to focus on climate justice and climate change challenges. CEQ's purpose is to ensure compliance with NEPA. Nothing more, nothing less. And yet, we have President Biden using this council to push through his outrageous and harmful executive orders and rulemaking, with CEQ's chief of staff describing the power Biden has given CEQ as unprecedented. So this isn't just our words. During his presidency, Biden has signed executive orders providing CEQ with more and more power over American citizens' lives, no longer solely focused on NEPA compliance, but instead on environmental justice per the president's orders. We have just begun to see the damage this rogue, relatively unknown agency can wreak on this country and our economy. Last July, we saw the results of this agency's activism at the Lower Snake River dams. The CEQ has been working behind closed doors with plaintiffs in an ongoing lawsuit over the Columbia River System Operations, EIS, all while promoting a supposedly open and transparent stakeholder listening process meant to develop a regional solution for salmon and the river system. This action by CEQ shows their goal is not a cleaner and more efficient economy and power generation, but instead forwarding their climate goals and trying to destroy any power generation that they cannot control directly. Mr. Loyola, we can all see the significant differences in how CEQ was run under the Trump administration versus the current one, permitting delays, a focus on climate justice, etc. However, there are lesser understood or seen differences influencing our country that my constituents would be surprised to hear about?
Well, if I was to name one, Congressman, I would say that in the Trump administration, we were building on the work of previous administrations, including the Obama administration. We recognized that doing a rule revision carries risks of inserting instability into a process that's already so unpredictable that Americans across the spectrum suffer from it. So we tried to have a very inclusive process and produce very common sense reforms that would have bipartisan buy-in and that would stand the test of time. That's why, as it turned out, the renewable energy sector was arguably the most immediate beneficiary of many of those reforms, as renewable energy capacity permitting doubled under the Trump administration. And what concerns me is that this process that CEQ has undertaken in recent years has been, I think it's fair to say, a more partisan and special interest group driven process than certainly the one that we tried to have in the Trump administration. And as a result, the CEQ has guaranteed that when there's another change of administration, there's going to have to be yet another change in the procedures for NEPA to make them more balanced once again. And so that's the danger that I see there.
Thank you very much. This is exactly the ripsaw effect that we see when executives on either side of the aisle start making executive orders and directing policy instead of utilizing the process that our founders created for us, which is this body creating the laws. And we have lost that, which has also created a loss of confidence in the general public in these institutions because they see them going off and making their own decisions, making their own rules, and completely in disregard for the rule of law that's been put in place. Mr. Chair, if I could squeak one more question in. Do you believe any of the President Biden CEQ's actions have violated the Constitution, Administrative Procedure Act, or the Supreme Court's precedent?
I think that there is a potential for that, and I'd like to take that question for the record, if I may.
Thank you very much, Mr. Chair. Thank you for
I
your
think
indulgence.
the gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. I want to follow up real quickly on Chairman Westerman's opening statement. America, during the last hearing, CEQ Chair Mallory, and CEQ, by the way, is an unauthorized agency created by the Biden administration, which has increased to a bloated budget and out-of-control agency. Chair Mallory refused to answer simple questions I had about foreign contractors. As a matter of fact, she refused to answer any more questions. Now, she wasn't refusing to answer me, but she was refusing to answer you. Every tax-paying American out there, because she, like so many of these other out-of-control agencies, well, they don't think they have to answer your questions. They don't even have to answer your comments you submit, because they don't care what you think. As a matter of fact, they think it's even beneath them to have to even answer your questions, or as you see, even show up. Because you see, for years, to Chuck Schumer's delight, we've passed omnibus bills up here. Omnibus bills have been crammed down the American people's throat with no oversight and no accountability by these out-of-control agencies, and it's done nothing more than but continue to embolden them. Well, I tell you what, I'm here to tell you, those days are over. Now, Mr. Chairman, with that being said, I'm excited that we do have those of you that are here with us today, and I thank you for that. Now, CEQ projected reviews, they're 0.5 years on average from reaching a record of decision. And at the most extreme, the average time to conduct a final EIS by the Federal Highway Administration is 7.37 years. And none of these timelines take into account the litigation that likely ensues for this final record of decision or ROD. So, Ms. Heaps, what are the reasons for an environmental impact statement to take almost 5 years to complete?
I think in some instances, environmental impact statements can take a long time based on what kind of studies are being done. If you're doing noise studies, if you're studying certain impacts to wildlife, if you have to do baseline research, so that could be one reason. I have not been privy to any interaction between an applicant and an agency to actually know what they're doing in that time until the NEPA document goes out for public comment. So there may be another witness here who has a better answer to that question, but I could speak more clearly to what happens when a document goes to public comment and then what happens after that.
Thank you. Well, I'll tell you what, Mr. Lewis, do you agree that these timelines are not acceptable?
I'm sorry, Congressman, please repeat that question.
Well, I was asking Ms. Heaps, what are the reasons that these environmental impact statements take almost 5 years?
Oh, why they take so long, right. Well, I'll give you a quick answer, but I would say that my colleague Mario Loyola knows much more detail here. But one reason is that it's to bulletproof the environmental impact statement from litigation. And so, because, no matter how many different factors or aspects you consider, because the world is such a big and complex place, some litigation group can always find some thing that the agency didn't consider, and then and sometimes courts will then just
And I would agree with
overturn
you.
the decision or make them do the study over, So litigation drives a lot of the time.
I would agree with you
expended.
100%. And so many times that our federal government, they move the goalposts due to these litigations and all these frivolous lawsuits that these environmentalists impose and start just, it's a,
And I could.
well, we'll give them a shot at it. Would you care to answer that?
Yes, Congressman, thank you for that, and thank you, Marlo, for creating more work for me. Well, I appreciate that as always.
He's sitting 3 doors
So,
down.
So, Congressman, I think that in addition to the factor that Mr. Lewis mentions, which is litigation risk that drives the agencies to an inordinate amount of time spent trying to make sure they get every comma and period right, is the fact that the NEPA process is so resource intensive for agencies that agencies can only produce a handful of EISs every year. And so you have, for example, the Nevada office of the Bureau of Land Management can only has the resources to work on 1 or 2 or 3 permit applications at the same time, given how much of the staff resources every one of these things costs, and suddenly they're facing 20 permit applications. Well, they can still only work on 2 at a time. And so that means that there's an enormous backlog of these things created. And as far as ways to resolve this, to help improve the situation and speed this up, I think I have several recommendations in my submitted testimony, and I've written about this a fair amount. I'll just say, I think it's very important that the agency not have unfettered discretion of when to start the clock ticking. So
He's over here tapping on me. I can answer that question as well, something called tort reform. Mr. Chairman, I'm sorry for going over, and I appreciate it, and I yield back.
I thank the gentleman from Georgia. The gentleman from Washington, Mr. Newhouse, is recognized for 5 minutes.
Thank you, Chair Gosar, and I appreciate very much the opportunity to be part of this hearing. Thank the guests for being here today. So I'm from the state of Washington. As you are familiar, the 4 lower snake dams are certainly what many people call, and me included, the lifeblood of central Washington. They literally transform an arid desert into bountiful farmland. They provide irrigation, an agricultural industry, navigation, flood control, a source of clean, renewable, CO2-free power throughout the region, and so they're very important. And to ensure their continued success, I've consistently engaged with many people throughout the region that represent utilities, public power, hydropower, certainly water groups, many groups that are impacted and benefit from the presence of the dams. You literally represent millions of people in the West, and this is such an important process for us to be talking about, and I appreciate you guys being here. The common theme, all of these groups consistently raise the same concerns that they have within the CRSO process, the Columbia River System operations, that the CEQ, the Council on Environmental Quality, has not adequately involved them. That's very frustrating. These are the stakeholders in this mediation process. It's very frustrating. In fact, in one case, stakeholders like the Public Power Council and the Northwest River Partners were invited to an August 18th, 2023 meeting, a meeting that was scheduled 13 days prior to the expiration of the mediation. So certainly stakeholders had a chance to express their concerns, I'm guessing they were registered, but none of their concerns were addressed or remedied. I was very excited when I came in the room and I saw that the name tag for Chair Mallory of the CEQ was there, and I apologize, Mr. Loyola, I mistook you for Mr. Mallory. So I was going to direct some questions to you, but not being able to do that, I'll have to redirect my thoughts to others. So, Mr. Sims, if you'd avail yourself, do you think that 13 days is enough time for CEQ to incorporate any potential recommendations into the mediation?
Congressman Newhouse, good morning. 13 days is certainly not enough for CEQ to incorporate our input.
Do you believe that, or in your opinion, I should say, how do you believe that this
lack of collaboration will impact the end result that we may see from this mediation process?
You know, sadly, sir, I would say as a fourth-generation Washingtonian myself, we're further apart than we were when we started this process. And I used a four-letter word earlier to describe it. It's a sham, S-H-A-M. I think that this process has really isolated folks from the ability to really engage and find true compromise in the middle. And I do believe that there is a middle for compromise. And I was sad to see Congressman Huffman leave the room so that we could address some of the issues he raised about salmon, because we do care deeply
Absolutely.
about the salmon in our region, the survival of the salmon, the habitat investments, the predation reduction investments that we're making. Those are all critical for their survival. And we're all in. We live in those communities, and we want those salmon to succeed.
So I'm kind of an optimist, I guess, not naively so. So I was glad to see the extension so that maybe we could address some of these longstanding concerns that I didn't think there was adequate time given to address. In the remainder of this extension that we have before us, what would you recommend that, in your opinion, CEQ could do differently than they have over the past 2 years to make sure that these concerns that are being raised are incorporated into the mediation process, and that we end up where we need to be, with a fair, equitable resolution?
Well, sir, I'm looking at the clock and seeing there's probably a long list of things that could happen, but I would say first and foremost is there probably needs to be some reading and some studying done at CEQ, and that is the current record from the U.S. government about where the government landed on the future of the Columbia River system, which was the CRSO EIS from September of 2020. As well, I think that as I outlined earlier, the NOAA report that CEQ has heralded and put forth is unsubstantiated and is a 180-degree difference from the former and established NOAA science in this basin. So we've got to actually do some homework in this region, and we've got to get folks back together to the table in a way where we can compromise. I'm hopeful we can do that in the remaining days of this stay.
Yeah, I am too. Like I said, I'm optimistic, but hopefully not naively so, and look forward to a positive resolution to this once and for all. Thank you, Mr. Chairman. I'm over my time, and again, I appreciate being allowed to sit in on this hearing.
Thanks for being here. The Western Caucus is always endeared here. I now recognize the gentleman from Texas, Mr. Hunt, for his 5 minutes.
Thank you, Mr. Chairman, and thank you, witnesses, for being here today. CEQ was originally created to issue guidance to federal agencies on how to comply with NEPA. Nevertheless, everyone in this room knows the CEQ has grown into an action arm for President Biden's radical eco agenda. Look no further than the Biden administration's settlement with the Sierra Club over a possible sighting of a rhesus whale in the Gulf of Mexico almost a decade ago. It's insanity. Instead of simply overseeing NEPA compliance, the CEQ is reshaping federal agencies as a vehicle of social change and leading the war on domestic energy production. CEQ and Biden's White House they care far more about ESG than they care about the American public and our livelihood and what we're going to do about having energy abundance for our future. Mr. Loyola, sir, thank you for being here. In your testimony, you mentioned that the American people need to understand that the goal of net zero is a fantasy, and given the delays and uncertainties of the permitting process. Could you elaborate on that, please? And for the record, sir, I'm from Houston, Texas. The entire energy corridor is in my district, so I can't agree more with this statement, but I would love for you to speak a little bit more about that, please.
Well, thank you for the question, Congressman Hunt. I would say that under current law, there are enormous constraints on the ability to deploy renewable energy on the scale and at the speed that would be required. Just to give an example, the Princeton Net Zero study talks about requiring 500 gigabytes of new solar capacity. That's about 1,000 utility-scale solar plants that would need to be built. That's an area approximately the size of New Jersey covered in solar panels.
Wow.
And I'll just point out, in the Snake River dams that we've been talking about, there's many very sympathetic stories on the ground of stakeholders. Every single renewable energy project has similar stories and has similar people opposing them. And the problem with the NEPA process is that it elevates small pockets, what can sometimes be very small pockets of local opposition, over national policy priorities and it's happening even with respect to the national policy priorities of the current administration, which hasn't been able to increase the rate at which renewable energy gets permitted because of this sort of local opposition. The problems operate at two levels. One of them is that the risks to any particular project are so enormous because of the uncertainties of the process that those projects in the project application phase, during the NEPA phase, have only very restricted access to financing. Only people who can afford to lose $25 or $30 million or $100 million on a permit application, who can literally afford to throw that money away, waiting for someone to call them back, and are only tempted to get into a project because of the promise of exorbitant returns on investment, which is a premium that is passed on to consumers
Always.
eventually.
Always.
All of these inefficiencies come at a great cost. And then the macro level issue, which I discussed a moment ago, which is that the entire process is so taxing of agency staff resources that the entire federal government's only able to produce 70 or 80 EISs a year. The entire federal government, in the last year, I mean, I don't know this for a fact, I'll take it for the record, but in the last year, I bet that the entire federal government has only issued 3 or 4 solar project permit applications. And in order to get to net zero, they have to build 1,000 solar plants and have them operational before 2035. So, I mean, I'm not a mathematician or anything, but doing the math, I don't see how they're going to get there. And so I think the principle that we followed in the Trump administration was that the uncertainties and inefficiencies of the NEPA process hurt everybody.
Yes.
And that making the process more predictable would be a benefit to everybody. Maybe not the cottage industry of litigation groups that has grown up challenging agency actions. But again, I don't see this as a partisan issue of Republicans versus Democrats. I see this as public interest versus special interests. And so what we tried to do and what CEQ will hopefully do in the future is to put the public interest in efficient and effective agency action first and try to streamline the NEPA process as called for in the Fiscal Responsibility Act.
Thank you very much for your answer, and I will yield back the rest of my time. And thank you, sir.
I think the gentleman from Texas, the gentlewoman from New Mexico is recognized for her 5 minutes.
All right, well, thank you so much, Mr. Chairman, and I do thank all of my colleagues for the rich discussion and debate this morning, and that is part of the democratic process, is to have debates about public policy and our goals and what we'd like to achieve with the tools of governance. But what we don't get to do is to make up facts and put false statements into the mouths of our witnesses and then try to get them on the record. So I will remind my colleagues that this is not behavior that is fitting with the decorum of this committee, and would like to correct some of the misinformation that's been stated here at this hearing today. First of all, let's talk about NEPA and CEQ. In 1969, this body on a bipartisan basis passed NEPA, and guess what? It actually authorized and created the Council on Environmental Quality, and then Richard Nixon signed it on January 1st, creating the Council on Environmental Quality. I heard some statements this morning that it was an unauthorized agency, and that is factually untrue. Second, I heard a lot of commentary this morning from various members about unauthorized activities of the Executive Office of the President. Well, this is how it works. Congress passes laws, and then the executive branch implements them. And last year and the year before, Congress passed the bipartisan infrastructure law, which is the largest investment in infrastructure in generations. And last summer, we passed the Inflation Reduction Act, which directed the Council on Environmental Quality, our executive offices, to implement the most comprehensive implementation of climate action ever in the history of the United States and of any government in the history of this planet. So the council and the other agencies of the executive office are carrying out their mandates, which Congress passed. Third, I heard that the Council on Environmental Quality is implementing unauthorized budgetary authority. Well, guess what? The U.S. Constitution says Congress holds the purse strings, and we authorized and appropriated that funding. And the reason why we did that is so that we could implement NEPA and actually expedite our infrastructure so that we could build out our clean energy and other infrastructure, and that is exactly what the council and other federal agencies are doing. Finally, I'd love to remind everyone here that administrative law and the way in which our Constitution laid out was that there's a separation of powers, and so each president gets to create an advisory body within the executive office of the president to advise that president on how they carry out their duty. They also can sign memorandums and executive orders that direct his agencies and his bodies to do what a president, he, and hopefully in the future she or they may choose to do, and that is exactly what the Council on Environmental Quality is doing. So I think it's just important for the purposes of the record to make sure that we are being accurate in what we're describing in terms of the law, congressional authority, executive authority, and the mandates of this agency. I do want to just take a moment to talk for a moment about the fisheries situation in the Pacific Northwest. While I do represent a state in the Southwest, I had the tremendous honor as a former Senate staffer to work for a senator from the Pacific Northwest and had the opportunity to work on these issues. And what I know to be true is that indeed, the fisheries of the Pacific Northwest are protected by treaty between the U.S. government and the tribes who signed those treaties with the U.S. government. And the subject of litigation is not only the Endangered Species Act, but the right of those tribes to access and utilize those fisheries in perpetuity. So it's important, again, that we're accurate about the law, we're accurate about the goals of litigation and why these things are happening. Finally, I just want to wrap up here and talk about accountability to agreements. 2 months ago, this body literally had a debate about whether or not we would shut down the global economy and accede to the demands of folks in the radical right who basically wanted to gut government functions. And as a pound of flesh, they mandated that the president and the rest of our country vote for a bill called the Fiscal Responsibility Act that cut funding for individuals who are struggling with food insecurity, that made agreements about how the budget would be implemented, that would cut overall spending levels if we didn't hold to those agreements, and which attempted to gut the National Environmental Policy Act, and which the administration is trying to implement in good faith right now. But you know who's not acting in good faith right now? The individuals who actually demanded that pound of flesh. Because right now, this week, we are just 2 weeks away from the government shutting down because we have not passed a budget that meets the responsibilities and the agreements that were in the Fiscal Responsibility Act. And we were supposed to take a vote today on one of those appropriations bills. And guess what? They couldn't even get a rule out to take a vote on the House floor. And so we're gonna go down to the floor after we adjourn this hearing, and we're gonna take a vote on electric cars, and these folks are gonna go home. So I say to the American people, let's talk about government accountability and responsibility, but let's make sure that Congress is doing its job, and let's keep the government open. And with that, I yield back.
I thank the gentlewoman. You know, it's priceless here. You know, we're going to run a $2 trillion deficit this year. $2 trillion. And we're not going to talk about that expenditure? Think again. You can't keep doing this. That's why our money's play money now. So, you know, I think the ranting and raving on both sides is merited because I think people are frustrated. Because we're not back to what the government should be doing. Congress defines the laws, makes those laws, and these agencies embrace them. Groups like Ms. Heaps have a right to intervene if they so feel. But we all have to do this together. And it's crazy. Now, when you look at this $2 trillion deficit, how much was it that was done in regards to the military? Here's a military that can't find 60% of its assets. Does that sound like something you want to throw a bunch of money at? Not me. I think every dollar that comes to the forefront should be accountable Yeah, I mean, determining that aspect to have it done. So I don't care for the grandstanding. I think it has a place because we have to look at each other and how we get this stuff done. Mr. Loyal and Mr. Lewis. When you talk about these green infrastructure projects, tell me how this worked with the Trump administration working collaboratively versus the Biden administration. Why was there so much more done during the Trump administration than the Biden administration?
Chairman Gosar, during the Trump administration, I think it's fair to say that attitudes towards renewable energy within the administration ranged from agnostic to hostile. But the president was very committed to efficient government processes, and especially very committed to cutting red tape and to making agency processes work efficiently. An important part of the one federal decision process was not just timelines and page limits, but also an accountability system that was developed and managed jointly by the Council on Environmental Quality and the Office of Management and Budget that held the agencies to report cards and brought up to the principals level, to the cabinet officer level, projects and processes that had fallen behind their published schedules. And in my opinion, it was this entire system of expedited procedures, added resources to expedite those procedures, and crucially, the accountability system that was put in place by OMB that increased the rate of permitting across NEPA reviews generally. And as a result, because renewable energy projects tend to be, for a variety of reasons, NEPA intensive, it emerged, not as an objective of the policy, but as a byproduct of the policy, that the renewable energy sector was an enormous beneficiary of the Trump-era reforms.
So let me intervene there. I thought my understanding was agencies in the Obama era actually looked at corridors that were actually pre-selected sites for these green energy. Is that true, and why did that not play a big part?
Well, I'll take as an example the 2012 solar programmatic environmental impact statement for the 6 western states, which was put in place in 2012 by the Bureau of Land Management in order to expedite solar project development in the part of the country that has the highest solar energy capacity factor, which is the desert in the western states, in Nevada and surrounding states in particular. They divided up the geographic area into solar energy zones, solar energy no-go zones, and then variance areas. The problems with the areas that they designated for solar energy development is that they were absolutely in the middle of nowhere and not near any interconnection points. And the long pole in the tent for all of this stuff is building the transmission lines. So they were in danger of building a bunch of solar projects that could be waiting for the rest of the 21st century for transmission lines to arrive. And as it turned out, when private developers started coming in and trying to develop solar projects under this scheme, they realized that the only feasible places to get a return on investment and get a solar project interconnected to the grid was within the variant zones. And the variant zones basically dialed everything back. Instead of having a programmatic permit where you could batch permit all of this whole group of solar projects, now you were back to square one with the same NEPA process that you had before. And so that was one of the instances where just not looking at it enough from, I think the failure there was to not look at it enough from the business people's point of view who actually have to develop these projects and try to figure out where it would make sense to develop them.
That's wonderful. I'm just going to ask you real quick, going down the line. What was the one question you wanted asked today? It wasn't asked, and what's the answer? We'll start with you, Mr. Loyola.
What is the most important thing?
No, what was the question you wanted most to answer?
So I'll say
what is the question, and then what is the answer?
Sorry, I'm trying to get out of this. Is suddenly Jeopardy. But I'm trying. So the question is, what is the most important thing that Congress can do to reform the NEPA process? And the answer to that question, and after conducting a study of how other countries do environmental review and permitting, is that I think the time may have come for Congress to consider and start studying a general consolidation of all of the environmental laws in a single statute, as the Netherlands and Denmark have done, which would consolidate all permitting within a single permitting agency with a single permit application and a single predictable timetable for projects of national importance that would still retain enforcement and regulation within the agencies that exist today.
Ms. Seep?
Thank you. I would have liked to be asked, how are the Phase 2 regs consistent with congressional intent of NEPA?
Say that one more time.
How are the Phase 2 regulations consistent with NEPA's congressional intent? And I think there's 4 ways, particularly with climate change and environmental justice. The Declaration of Congressional Intent is that Congress recognized the profound impact of man's activity on the interrelations of all components of the natural environment. That's climate change as an umbrella, especially as related to resource exploitation. Congress declared it the continuing policy to use all practicable means and measures to create and maintain conditions under which man and nature can exist in productive harmony. Said they recognize its continuing responsibility of the federal government to use all practical means to improve federal decisions, to fulfill the responsibilities of each generation as a trustee of the environment for succeeding generations. We know through Juliana, we know through the Montana litigation that our young generations are demanding that we take action on climate change. And then finally, that Declaration of National Environmental Policies Congress recognizes each person should enjoy a healthful environment. That loops in environmental justice. Thank you.
Thank you. Mr. Sims?
Yes, thank you for that question. The question I was hoping we'd ask is, can you talk about the balance you work to achieve between the health of salmon and production of clean, renewable hydropower? And my answer is that I represent nonprofit electric utilities, and 25 cents on every dollar is spent on fish recovery, and we are making meaningful impacts. We need to talk in our region more about sustaining the harvests for treaty tribes, for sure, but as well, we need to talk about the offshore harvest that is happening on an annualized basis and the massive take of fish. So as we're trying to produce fish, they're also being hauled in. I think as well, we are facing more and more extreme weather events in our world, and you certainly did raise that, I think, in your opening comments, and we definitely are seeing utilities being stretched more and more. In fact, last year, California hit a peak, 51 gigawatts during Labor Day of 2022. The Northwest came to the rescue with actually those lower Snake River dams. So it's all about a balancing factor. And for us, I think what we're trying to do is make sure folks realize we actually live and work in this basin, we care deeply about it, and we're trying our best, like Congress, to find that balanced pathway between all the needs that are put on this vast river system. Thank you.
Thank you. Mr. Lewis?
I would have liked to have been asked to elaborate a bit on the CEQ's exaggerated understanding of the climate risks that we actually face. CEQ in its greenhouse gas guidance basically thinks that agencies have at their fingertips an excellent set of resources in terms of modeling and projections of climate risks that they can rely on to inform their decisions. And one of the things that I stressed in my testimony is that for years, a set of emission scenarios have dominated all the official climate impact assessments, whether it's the Intergovernmental Panel on Climate Change or the U.S. National Climate Assessment. These scenarios, they're called RCP 8.5 and SSP 8.5. They're basically the high-end emission scenarios. And just to give you a sense, about just since 2019, 17,400 papers have been published in the peer-reviewed literature examining climate risks in terms of this RCP 8.5. Now, it turns out that the latest information shows that this emission scenario, which is the dominant scenario for years now, or more than a decade, exaggerates the likely quantity of carbon dioxide emissions in the global economy by more than double by the year 2050 and by more than 5 times by the year 2100. So there is this enormous systemic bias, if you will, in the climate impact assessment literature. And I don't think that CEQ is aware of any of this. They certainly don't take notice of it. There are newer scenarios that are much more realistic, including those produced by the organization Resources for the Future, and then the International Energy Agency also. So anyway, there are some aspects to climate science there that I think they're completely missing. Also about the models that are used. The generation of models that was used in the 2013 Intergovernmental Panel on Climate Change report, and then by our National Climate Assessment, and then the later generation called CMIP6, if people are interested in the names, in the 6th assessment report of the IPCC. All those models overestimate or hindcast more than about 2.5 times as much warming as has actually been observed in the tropical mid-atmosphere, the bulk atmosphere. So the practice in climate science has been to run inflated emission scenarios like RCP 8.5 with these overheated models, and then that becomes the consensus. And based on that consensus, people who are clever with words will elaborate a narrative of existential threat and crisis and emergency. And I think all of this really needs to be toned down and rethought at the highest levels of our government.
Well, I thank you so very, very much. You want to put that in the record? Go ahead.
Mr. Chairman, before we adjourn, I'd like to ask for unanimous consent to enter into the record this letter that has been signed by 33 organizations in support of CEQ's NEPA Phase 2 rule.
Without objection, so ordered.
Thank you very much, Mr. Chairman. I would just like to take one short moment, with your permission, to correct the record on the previous statements that were just made. Global circulation models show that under all carbon scenarios, including the highest levels of emissions, and if we hit our global goals for carbon, that we will continue to see increased heating and challenges around changing weather and climatic issues. So we can't make up the science here, and I think it's important that the record reflect that the last statements were untrue. Thank you.
I don't know that they were untrue. I think you have to didactically look at them. And I think we occupy also such a small point of time on this world. But take a look at trees. You know, trees tell us a lot more. Rocks tell us a lot more. And so you have to constantly go back to the data to go checking and reassessing it. And that's where that peer review comes into place. That's a big key. And so from that standpoint, I think, I'm going to tell everybody, thank you very much for the debate. I appreciate it. I thank the witnesses for all their comments and testimony. Now, I just will tell you that the members of the committee may have some additional questions for you. And we ask that you respond to these in writing. Under Committee Rule 3, members of the committee must submit questions to the subcommittee clerk by 5 p.m. on September 19th. The hearing record